I am the Commission's designated presiding officer for this hearing. Let's have appearances, please, beginning with the applicant.
Good morning, Yvonne Hogel on behalf of Rocky Mountain Power.
Do you have any witnesses with you?
Oh, I apologize. Yes, Mr. Paul Clemens is here, and he's the Director of Commercial Services for Rocky Mountain Power. Kyle Moore is also here, although he's not a witness, and he is a Senior Structure Pricing Marketer for Rocky Mountain Power. Thank you.
Thank you.
Good morning. I'm Justin Jetter with the Utah Attorney General's Office. I represent the Utah Division of Public Utilities, and with me at council table is Charles Peterson with the Utah Division of Public Utilities.
Robert Moore with the Attorney General's Office, representing the Office of Consumer Services. With me is Bella Vastag. He's a utility analyst with the office.
Thank you, Mr. Moore.
And I'm Adam Long with Smith Hartwickson here on behalf of Thayn Hydro. My sole witness is Rick Castor, who's sitting right behind me.
Thank you, Mr. Long. And Ellis Hall Consultants, LLC was also granted intervention in this docket. Are they present today? No? Okay. Does Ellis Hall have an intention of presenting evidence or otherwise participating in the hearing?
Not at this time.
Okay. Well, you're welcome to be here. Thank you.
Thank you, sir.
I'm sorry, can you repeat your name for the court reporter?
ELLIS-Hall, H-A-L-L Consultants.
What is your name?
Oh, I thought you said the name of the company. Untitled Chapter.
Could you spell that, please?
K-I-M-B-E-R-L-Y, C like Charlie, E-R-U-T-I.
Before we begin, are there any preliminary matters the parties would like to address? I have a hearing statement on the bench from the Office of Consumer Services.
Yes, we handed those out to the court reporter to make it easier to transcribe Mr. Vastag's testimony. Statement, sorry.
Okay. Is there any objection to my receiving this from any of the parties? Thank you. Given that legal briefing was submitted in this docket, I expect counsel might want to make some sort of legal argument on the record. I don't know if you want to do that, or if you choose to do that, you'd prefer to do it before we proceed with witnesses, or you'd like to make a statement at the end of the hearing. I offer that to any of you who would like to make a comment now.
Thank you, Mr. Hearing Officer. The way that the company will approach the issues in the case is Mr. Paul Clemens will be the policy witness in this case. We believe that there is an opportunity to present both, well, sort of a general policy statement that will include facts and a little bit of law. And if necessary, then I will certainly interject and add anything that I feel was omitted. Thank you.
Mr. Cheddar.
Morning, Your Honor. The division didn't prepare an oral argument summary of our brief. I suppose this is kind of a mixed question of fact and law. We intend to present a witness that will summarize the comments that we've provided. And I think our position is fairly clear from our brief, which was also fairly brief, that in this case we think that the facts in a very narrow, fact-specific view of this particular situation may support a LEO and support a legally enforceable obligation to support the prior pricing. I think that the commission at this point has a pretty thoroughly established timeline of the negotiations that occurred, and a fairly well briefed by the various parties legal analysis of sort of the boundaries of where states may determine when legally enforceable obligations occur or don't, and it's probably a pretty good question for the commission to answer, I guess, in this case. So that's the only initial statement I'd like to put on the record. Thank you.
Thank you, Mr. Jetter. Mr. Moore?
At present, the office will rely on its briefing, although we would like to reserve the right to, if needed, as the hearing develops, to provide some legal argument on that issue at the end of the hearing.
Understood. And Mr. Long?
Like Mr. Moore, we think the issues have been fairly well briefed and thoroughly presented to the commission at this point. We don't anticipate making a formal legal argument or any sort of summary of the briefing position. As a very basic summary of Thayn Hydro's position, Thayn Hydro effectively wants the old Schedule 37 pricing, and from Thayn Hydro's perspective, how they get there is irrelevant. Thayn Hydro also believes that if it comes down to a legally enforceable obligation argument, it's clear that that obligation existed based on the facts, and I will ask some questions of Mr. Castor to give his own version of those facts.
Thank you. In terms of order of the presentation of the evidence, my instincts tell me it makes sense to begin with the applicant and then perhaps go to Thayn and then the division in the office. Is there any objection to that order?
Not from the division. That seems like a reasonable way to proceed to.
No objection from the office.
No objection from Rocky Mountain Power.
None from Thayn either.
Excellent. Then we'll begin with the applicant, Ms. Ogle.
Your Honor, the company calls Mr. Paul Clements as a witness, and I don't know if you want him to follow on to the witness stand or if he can give his testimony where he is now.
I believe our court reporter would prefer he come to the stand. Make her job a little easier. Mr. Clements, do you swear to tell the truth?
Yes.
Thank you.
Good morning, Mr. Clements.
Good morning.
Can you please spell and state your name for the record and state your position with the company?
Yes, my name is Paul Clements, Clements. I'm currently Director of Commercial Services for Rocky Mountain Power.
And can you provide some background and how you became involved in this case?
Yes, for the past 12 years, I've been responsible for negotiating qualifying facility power purchase agreements for Rocky Mountain Power, either directly negotiating the agreement myself or in a managerial standpoint, overseeing those who negotiate the agreements.
And specifically, do you have a background as to your involvement in this case that you would like to give?
Yes, I've been familiar with the negotiation process for the Thayn Hydro power purchase agreement. People who are under my employ negotiated the power purchase agreement, and I was involved in directing and managing their work.
Okay. So in your capacity, did you assist in the preparation of the power purchase agreement in addition to the subsequent company filings related to the power purchase agreement?
Yes, I did.
Okay. So do you adopt the company's filings here today as your own policy testimony?
Yes, from policy standpoint, I do.
And have you prepared a summary that you would like to give today?
I have.
Please proceed.
Thank you. Good morning. If I speak too quickly, please interrupt me. Pursuant to the Commission's provisional conclusion of law issued on March 4th, 2016, the purpose of today's proceeding is to determine whether a legally enforceable obligation, or LEO, L-E-O, that will be a term you'll hear frequently today, was established by Thayn Hydro prior to either the Commission issuing its pricing order on September 18th, 2015 in the Schedule 37 docket, or the Commission issuing its contract duration order on January 7th of 2016 in the qualifying facility contract term docket. The pricing order on September 18th, 2015 established new pricing that would apply to Thayn Hydro. The contract duration order reduced the maximum contract term that would apply to Thayn Hydro. Thayn Hydro asserts that a legally enforceable obligation was created prior to the issuance of the pricing order. The company does not agree with this assertion. I will detail why the company does not agree in my remarks today. It's also detailed in the company's brief. Thayn Hydro further believes the Commission could decide this matter under extenuating circumstances, the same logic that was used for the Three Peaks Power Purchase Agreement in docket number 15-035-70. Thayn Hydro asserts that the Commission does not need to address the LEO issue in making a determination in this docket. The company agrees with that position and agrees that the Commission need not resolve the LEO issue in this proceeding and instead could evaluate and consider the specific facts of this case in making a determination as to what is just and reasonable. Regarding the issue of the establishment of a LEO, the FERC has determined it is up to the individual states, not the FERC, to determine the parameters of a legally enforceable obligation. The FERC has also explained that the purpose of the LEO is to prevent utilities from refusing to enter into a contract with a QF counterparty. To be clear, at no point prior to the pricing order or prior to the contract duration order did the company refuse to enter into a contract with Thayn Hydro. I will briefly summarize the key dates and activities between the time Thayn Hydro first contacted the company and the time of the pricing order. On July 7, 2015, Thayn Hydro first contacted the company regarding renewing their contract that was set to expire at the end of 2015. On July 14, 2015, the company provided a draft contract to Thayn Hydro. The contract, as first delivered, was not an execution form and was clearly labeled as a working draft that did not constitute a binding offer. While the contract is a renewal of an existing QF agreement, the existing contract between Thayn Hydro and the company was put in place 20 years ago, and the draft provided by the company on July 14th reflected the most up-to-date terms and conditions for similarly situated QFs, so there were several commercial terms that had changed from the existing agreement. On July 22nd, 2015, Thayn Hydro sends an email to the company stating it commits to sell its output under Schedule 37. This commitment occurred just 2 weeks after initiating discussions, without any further exchange of draft contracts. The company views this date as the date on which serious negotiations began between the parties, but not the date on which an agreement was consummated. Regarding the timing of negotiations or the duration of negotiations, the company notes the typical time to complete negotiation of a standard qualifying facility power purchase agreement is almost 3 months, not the 2 weeks that occurred between the first contact and Thayn Hydro's July 22nd email. The company further notes that not all terms were agreed to at that point. Specifically, there were negotiations ongoing related to the level or the amount of insurance required, and regarding an issue related to a default provision if minimum delivery requirements were not met. This ongoing negotiation was evident in the emails between the parties on August 4th, 2015, and even in some emails as late as November 2015. In those August 4th, 2015 emails, Thayn Hydro stated, quote, "One item that causes me concern," end quote, and, quote, "I would appreciate you checking into the necessity of adding the requirement," end quote. At that point in time, it appeared that Thayn Hydro was not willing to commit to sell under the contract in its then current form because it continued to inquire regarding changes to the insurance provisions. This is further supported by communication between the parties on September 17th, 2015, where Thayn Hydro inquired again regarding the insurance amounts. Then on September 18th, 2015, the pricing order was issued. And at that point in time, the company could no longer execute an agreement with Thayn Hydro under what we're referring to as the old Schedule 37 pricing. On October 1st, 2015, the parties reached agreement on the insurance terms. And the agreement that was reached resulted in insurance terms that were lower than those being initially discussed in August. and the parties reached agreement on a final version of the contract. So to summarize the key points of this timeline relevant to the proceeding today, at no point did the company refuse to execute a contract that was tendered for signature. Second, the company negotiated in good faith over the ordinary course of business, including attempting to resolve issues and negotiate terms when requested. One key point for consideration today, and this is in response to the OCS recommendation, or the Office of Consumer Services recommendation. There is no evidence demonstrating that the inquiries regarding the insurance amounts and the other commercial terms were unconditional, meaning the company cannot be certain that Thayn Hydro would have committed to sell under an agreement with the higher insurance amounts and other issues, or whether a lower insurance amount and resolution of those issues was a condition of their commitment to sell. In conclusion, the facts and the associated timeline do not support Thayn Hydro's assertion that a LEO was established through a commitment to sell prior to the pricing order, and the company does not believe the Commission should determine that a LEO had been established. As I mentioned earlier in my summary, the company agrees with Thayn Hydro's suggestion that the Commission could decide this matter under extenuating circumstances without addressing the LEO issue. These facts are very similar to the facts reviewed by the Commission in the Three Peaks Power case I mentioned earlier. Of particular importance to this issue of extenuating circumstances is the unique time involved with the pricing order. The hearing in the Schedule 37 docket occurred on September 14th, 2015. The pricing order was issued just 4 days later on September 18th, 2015. The Schedule 37 docket was a contested proceeding where all parties were not in agreement. It is unusual for the Commission to issue an order so quickly following a contested proceeding. To be honest, the issuance of the pricing order so soon after the hearing caught the parties off guard. Based on my personal involvement in the negotiations and my experience with similar negotiations, it is reasonable to assume the parties could have finalized negotiations and possibly entered into a contract prior to the pricing order had the parties known in advance that the order was imminent or about to be issued. On a similar note, regarding the applicable contract term, which would be the second issue in this proceeding, the parties reached agreement on all commercial terms in early October 2015, well in advance of the January 7th, 2016 contract term order. The parties did not execute a contract in October after that agreement was reached because the parties were working to resolve the issue related to the applicable pricing. It is probable that the parties would have executed a contract prior to January 7th, 2016, or the contract term order date, had there not been an ongoing dispute over the pricing. In summary, to answer directly the question raised by the Commission in its provisional conclusion of law, the company does not believe a LEO was established prior to the pricing order. However, as I explained today, the company does not believe the Commission is required to address the LEO issue in order to resolve the issue before the Commission today. And the company believes the Commission can evaluate and should evaluate and consider the specific facts of this case, including the unique nature and timing of the pricing order in its determination of the applicable rate and contract term for Thayn Hydro. And that concludes my summary.
Mr. Clements is available for cross-examination.
Mr. Long, we'll start with you.
I have no questions for Mr. Clements.
Mr. Jetter?
I have no questions for Mr. Clemens. Thank you.
Mr. Moore?
No questions from the office.
Mr. Clements, I do have a few questions. First of all, the initial contact that Thayn corresponded with at Rocky Mountain Power is a Mr. Uni.
That's correct?
Did I pronounce his name correctly?
Yes, John Uni.
I can't remember where in the briefing, but I remember seeing a representation that during the negotiations, Mr. Uni was laid off. Is that correct?
Yes, during the negotiation process, Mr. Uni left the company. That's correct.
All right. There's been testimony in other dockets, and it's the Commission's general understanding that the company has been a little overwhelmed with the volume of QF requests that have came in the recent past. And I don't want to delve into Mr. Uni's personnel file. It's none of our business. But were there factors that contributed to his departure aside from the company's determination that it didn't need as much assistance in processing QF contracts?
I'm not aware of the facts that led to his departure from the company, so I can't speak to that. In terms, if I can expand and respond in general to your question regarding the amount of work that was occurring at that point in time, that was not a factor in this proceeding. It's my testimony, my opinion, having done this for the past 12 years, that the course of negotiations for this power purchase agreement were relatively standard, if not quicker than what we would typically see. They requested a PPA on July 7th. The draft was delivered 1 week later. What occurred after Mr. Uni left the company, I believe there were some vacations between the two parties. But the pace of negotiations, in my opinion, was fairly routine or average.
So you're saying that the pace of the negotiations was not affected by Mr. Uni's departure?
Not in my opinion, no.
And I'll invite your counsel to interject with respect to any of these questions because they do delve into legal issues. With respect to the company's position that the commission would be justified in finding that extenuating circumstances warrant granting the otherwise outdated pricing to Thayn Hydro, the company has referenced the Three Peaks matter, which was a Schedule 38 matter. And Schedule 38 does expressly provide that the commission can essentially postpone or give extensions to otherwise existing deadlines under Schedule 38, which outlines a process for contracting. To my knowledge, Schedule 37 contains no such language. Does that affect the company's analysis of whether or not the commission has authority to find extenuating circumstances exist in this situation and therefore grant the otherwise outdated pricing?
No, I'd be happy to answer that. In my opinion, it does not. And here's why. Schedule 37 has just prices, essentially. It's a tariff that has published prices. Schedule 38 includes a process that governs negotiation of the power purchase agreement. There is nothing in Schedule 37 that dictates the process for negotiation. And so I think it's reasonable to look to Schedule 38 when it comes to contract negotiation issues to make sure there's consistency between what occurs with smaller QFs under Schedule 37 and larger QFs under Schedule 38. So I don't think it's unreasonable to use the contract negotiation principles under 38 when evaluating issues under 37 that are related to contract negotiation process.
I would like to add to that as well, if I may. I agree with what Mr. Clements has just stated, and I would also add that the commission, it is the company's position that the commission has vast discretion and jurisdiction in its jurisdiction over utilities and in its findings of just and reasonable and results that are in the public interest.
Thank you. Going back to a more fact-specific matter, Mr. Clements, I wonder if you could just elaborate a little bit more on the record concerning your opinion of the materiality of the umbrella insurance requirement and the default provisions that were being negotiated from the perspective of the company to the overall agreement.
I would say there were two issues that were really outstanding. One was the level of insurance that was being required, and one was an issue related to a default provision in the contract. I would consider both of those issues to be material, as we have had issues with other qualifying facilities who have been unwilling to execute agreements that had terms similar to those. They have been issues that have held up execution of other agreements, is the best way to put it. So I would consider them to be in the bucket of material terms, are terms that would hold up potential execution of an agreement.
Just one more question. With respect to the company's position that no LEO was incurred in this case, at least prior to the commission's issuing of what's been referred to as its pricing order, does the company find relevant the fact that this particular QF facility had been in existence and actively doing business with the company for a number of years, had an interconnection agreement? Are those facts relevant to the inquiry?
I think they are relevant, and that I think it gets you further down the road towards a LEO, because your starting point is well down the road. So I think it's very relevant when you compare it to a greenfield QF who has quite a distance to travel down that road. The question when it comes to a legally enforceable obligation is not where you're at on the road, it's if you are at the end of the road and you've made that commitment. I would say they started well down the path because they already had their interconnection agreement, but I don't believe we had a full unconditional commitment because we still had those outstanding issues.
Thank you, Mr. Clements. That's all the questions I have for you. If any, Ms. Hogle, looks like you have something to say.
Yes, I just have a couple of questions on redirect.
Sure.
Mr. Clements,
Ms. Hogle, may I interrupt you? Is there any other party that would like to ask any questions? I'd like to give you the last word, so I think
Okay.
it makes sense to see if anybody else has any questions first.
No questions from Thayn Hydro.
Mr. Jetter?
I actually do have just a brief couple questions kind of relating to the questions that have just been asked to Mr.
Sure.
Clements. Could you briefly describe, I guess with the background sort of to set up this question, Schedule 37 is designed as a fixed rate for QFs that are under a certain size, is that correct?
That's correct, yes.
And it includes pricing terms, but it does not include terms like insurance or the process for negotiating the other terms that are not included directly in the Schedule 37 tariff. Is that correct?
Correct. Schedule 37 only includes pricing.
Can you just briefly describe, and I don't need in detail everyone, but what other terms are significant that you negotiate outside of the pricing term?
The other material terms would be performance guarantees. So if you don't meet a performance guarantee, meaning you don't deliver what you say you're going to deliver, and that happens to be one of the issues that was in question still. Credit always tends to be a material issue, how much credit is going to be posted. The other other material issues would be insurance terms, start date, liquidated damages if they fail to come online when they say they're going to come online, default damages if a party defaults over the course of the agreement, termination damages, what happens if one of the parties defaults and the agreement is terminated. So the material terms of the agreement typically are if one party doesn't do what they say they're going to do, what happens? And there are quite a few of those.
Thank you. And so is it fair to say that before you would, I guess, sign a PPA or consider it a binding agreement, then in those cases you would, those are primarily for evaluating the ability and the reliability of that QF to be able to deliver what it claims it's going to deliver?
Yes, that's correct. Before the commitment can occur, they must make sure that they can commit to the terms and conditions that are included as part of the delivery of the energy.
And that's where your concern is with the Greenfield project, is that right? That they may be willing to, I suppose, even sign the PPA without any ability to actually deliver?
Yeah, the Greenfield project really has two primary differences. One is they typically don't have an interconnection, and we found that tends to be a great unknown in the process and often takes longer than what is expected. So having an interconnection is a major step towards reaching that level of commitment. Second, if they've already been an existing project and executed an agreement with us, then there are likely many terms in that existing agreement that would carry over to the new agreement. So we're starting from a point of mutual agreement on many concepts before. So I would say a greenfield is definitely different than a renewing contract.
Okay. And is that fair to say that's been also your experience in the number of, I don't want to name them specifically, but we have some typically one-year PPAs with some UFs in Utah.
Yes, we have some existing qualifying facilities that are connected to the grid and operating that have one-year power purchase agreements. We tend to renew those each year. That renewal process tends to be fairly streamlined, but it still often takes several months.
Okay. Those are all the questions I have for Mr. Clemens. Thank you, Mr. Clemens.
Mr. Moore?
The office has no questions.
Ms. Hope?
Just a couple, excuse me. Mr. Clemens, Mr. Hammer asked you about the materiality of the fact that the insurance appeared to be a problem for Thayn Hydro. Is there evidence in the record as to the level of materiality in terms of an increase in price for Thayn Hydro that they consider it to be, or that anybody could consider to be material?
Yes, Thayn Hydro indicated to the company that the insurance amounts that were being requested would result in, I believe it was a 300% increase in the premiums. And the company felt like that was a material amount that was of concern to them based on comments they made to the company.
And then just another question, Mr. Hammer also asked you about the whether in a Leo determination it was relevant that this particular PPA was a renewal. Can you tell, and I think you've already said this, but in the company's experience, is it also relevant that the average time for negotiation of similarly situated renewals or renewals was what you have testified that it was?
Yes, so our typical time to negotiate even a renewal PPA is 2.5 to 3 months. And an existing contract starts further down the road towards a Leo, but it's not how far you start, it's where you are when you finish. And you have to get all the way to the finish line to have a commitment, to have a legally enforceable obligation. And so an existing agreement, you start in a much better spot, but it's not where you start, it's where you finish when it comes to a legally enforceable obligation. And the company does not believe we had reached that finish line prior to the pricing order.
Thank you, that's all I have.
Thank you. Mr. Clements, you're excused.
Thank you.
And we will proceed to Mr. Long.
Thank you, Mr. Hearing Officer. Thayn Hydro would call Rick Castor.
Mr. Castor, do you swear to tell the truth? Thank you.
So, Mr. Castor, your job here, unlike Mr. Clements, your job here is purely as a factual witness. You are one of the part owners of Thayn Hydro, and your purpose here is to give the commission a firsthand report of how this process went, to add any details or information that we haven't accurately captured in the pleadings. So I won't be asking you any legal questions, and I won't be asking you to make any conclusions. And I'm not asking you to read a prepared statement. As I said, the goal is to get your version of the events with any details that only you can add. So if you would, for the benefit of the commission, would you introduce yourself, state your name, and describe your involvement with Thayn Hydro?
My name is Rick Castor. I live in Idaho, been working on hydro plants since about 1980. Met with the Thains about 1990. We partnered with them and developed their project. We sold power 3 or 4 years on a short-term basis.
Yeah, okay. Sorry. And then we signed a 20-year contract that ran from 1996 to the year 2000. And so in July of 2015, I called John Uni to start the renewal process. We'd worked with John Uni before on some other issues, so I had his number and called him. And so about a week later, he sent me the template. We got started on it. It was an extremely easy renewal.
Mr. Castor, if I can interrupt, I don't want to get ahead of ourselves.
Yeah.
Just so we're all on the same page, and again, for the commission's benefit, could you give me a real brief rundown of what the Thayn Hydro project is, and also describe the recent diversion dam improvements?
Yeah, it's a 575 kilowatt small hydroelectric plant. It's near the city of Green River. It's at the end of an irrigation canal that also serves some irrigators. Last winter, the diversion dam in the river was replaced at a cost of several $millions. The local water users agreed to cost share on that dam. So we're the largest water user, so we've made a pretty big commitment there to help cost share on that dam.
And what's the current state of the hydroelectric facility? Is it generating power?
It is running at this time, yes.
And that's under an interim PPA at current Schedule 37
Yes,
pricing?
that's right.
So over the years, when you deal with Rocky Mountain Power, was John Uni your contact? Was there anyone else that you dealt with on a regular basis?
In the early years, in the early 1990s, John wasn't there, but seems like in the, I don't know, at least 10 years ago or so, we started working with John Uni.
So he was the person you'd go to for questions or concerns or when something went wrong?
Yes, that's correct.
So you started at least going into the renewal process for your current, or renewal process to renew your then existing PPA. And you stated that you talked to John Uni in July or so.
I called him on July 7th,
And when did your old PPA expire?
the end of 2015.
So you called John Uni with 5 or 6 months before your PPA expired, and he then told you about the imminent pricing change?
He did. I asked him for a schedule of the pricing. He sent me both the current and the proposed pricing.
So at that point, John Uni told you that, and if I'm putting words into your mouth, please stop me. John Uni told you that pricing would change, and Thayn Hydro then asked for the process to be expedited.
That's correct.
So throughout this process, even before you contacted John Uni, did Thayn Hydro consider selling power to anyone else or consider not renewing the PPA with Rocky Mountain Power?
No, we didn't.
And why not?
Well, we already had an interconnect there. It's all set up. I think trying to wheel power for such a small project would be cost prohibitive, so we didn't even consider that, no.
And so Mr. Clements mentioned an email you sent to John Uni on July 22nd, and I'm paraphrasing, but essentially saying that Thayn Hydro was committing to sell output at the then effective Schedule 37 pricing. Is that correct?
That's correct. I had, excuse me, I had asked John if there was any way we could lock in the existing rates by, we'd sent a letter of intent or something similar to that, and he responded by saying that if we committed to the existing rates via email, that would lock us in on those rates. So later that day, I sent that email.
So at that point, did you expect to discuss the pricing issue for the next 20 years ever again?
I felt like the pricing issue was resolved at that point in time.
But to that point, you hadn't actually signed the PPA.
No.
And so from your conversations with John Uni, how did you expect the PPA renewal process to play out, right? You've stated that you thought pricing was taken care of. but the contract wasn't actually signed.
Yeah, we didn't just sit on our hands, we just dove right into it, and within a couple of weeks, John had the PPA ready to, well, he said he submitted it internally, and the same day on August 4th, he gave me the answer on the default question, so that was resolved. The only outstanding issue at that point in time was the question about the insurance. I had raised the insurance question in a voicemail to him on July 17th and followed up with an email to him on the 21st. So it just appears that it was something that slipped past John Uni, that he covered everything else extremely well, but it seemed like the insurance question slipped by him. So on August 4th, I was reminding him that I had a question about the insurance. It was not a new question that I brought up then. So, and then August 5th, John stated that he had submitted the question to the insurance department and that the PPA would be ready to sign in about a month.
So at that point, the PPA was already in Rocky Mountain Power's internal review process as far as what you knew from John Uni.
That's what he told me, yes.
And at any point, did you tell John Uni or anyone else at Rocky Mountain Power that the insurance question was a deal breaker, or that the PPA as submitted for review was unacceptable to Thayn Hydro?
No, there were no deal breakers in the entire template. In fact, the PPA that John submitted on August 4th is almost a carbon copy of the template I received on the 14th, other than we filled in the blanks, of course, on the projected power outputs, and I emailed him copies of the interconnection agreement and so on.
So from the very first week of August through I think August 29th, when John Uni told you that he was leaving the company, did you hear anything from Rocky Mountain Power or from John?
No, I didn't. He said it'd take about a month, so I was giving him a month. And before the month was up, he sent me an email saying that his last day at work was going to be September 1st.
And you had discussed with John Uni the imminent pricing change. Were you concerned about that delay at all? The month that he wasn't talking to you?
Personally, I wanted to get it done before the holidays, but I felt like the pricing was established, but at the same time, I just wanted to get it done.
So had someone asked you in say August, so pre-pricing change, what you thought would happen? I'm assuming you thought the pricing was taken care of and the PPA would get signed when it eventually ran through the process. Is that accurate?
I expected a copy of the PPA that we could sign somewhere around the 1st of September, and an answer to the insurance question concurrently. My understanding was that they were considering the insurance question and reviewing the PPA concurrently during the month of August.
So after John Uni left, can you tell me what happened? You mentioned that John Uni was leaving the company as of the end of August.
Yeah, everything's just seemed to come to a screeching halt. I called I emailed Bruce Griswold on September 1st, told him I was sorry to hear that John was leaving, that as far as I was concerned, the PPA was done. The only thing I was waiting on still hadn't heard back on the insurance question. So then September, it wasn't until September, well, Bruce emailed me back and said, give me 2 days and I'll get back to you.
So at that point, had Bruce given you the PPA, the same PPA that was submitted with the $5 million umbrella policy, what would you have done with it?
If that was their answer, we would have signed it. It didn't matter what their answer was. Whether it was $5 million, $3 million, or no umbrella, we were going to sign the contract.
And there was never any question in your mind that you would continue to sell power to Rocky Mountain Power and that essentially the status quo would remain unchanged except pricing updated to the current Schedule 37?
Absolutely.
So eventually, after being introduced to Paul Clements and Kyle Moore, who are here with us today, you were informed that the old Schedule 37 pricing was not available. Is that an accurate statement?
Well, Kyle left me a voicemail on, I believe it was September 16th, that he was going to be replacing John Uni. I emailed him back and said, well, that's fine. We're still waiting on an answer to the insurance. So from the date when I first brought up the insurance question on July 17th through September 17th, it's actually about 9 weeks, and 5 times I asked the question. I didn't get a single response, other than John Uni telling me that they'd submitted it to the insurance department.
But either way, that insurance, I assume from Thayn Hydro's perspective, you would prefer not to pay more for liability insurance unless it's absolutely necessary.
We're not guaranteed a profit like Rocky Mountain Power. We just can't go around throwing money away. So I think it's excessive, but it wasn't going to prevent us from signing the contract. No.
And so eventually through discussions with Rocky Mountain Power, you came to the conclusion that the group, the hand in hand, the parties would approach the commission and seek approval of the old prices.
Yes, initially they told us that they could not approve the old prices, and we went back and forth, and I think Kyle sent me a number to call the DPU if we wanted to file a complaint, and we discussed it back and forth. I told him I'd rather not file a complaint if we didn't have to, and eventually we got around to Paul and Kyle saying that we agree you should get the old rates, but we need to go through the DPU. So that's where we're at now, I guess.
Mr. Clements mentioned extenuating circumstances. Can you tell me your understanding of what the situation is and essentially why we're here today?
Well, I believe that if John Uni had been allowed to finish the process, we wouldn't be here today. Or else if somebody had been appointed immediately after he was terminated or he left or whatever happened, we wouldn't be here today.
So at the point where John Uni left, end of August, as far as you were concerned, was there anything left to do other than sign the PPA?
No. Like I said, I was waiting on an answer. I mean, we really have no leverage in these negotiations. We don't have anything that the power company wants. It's not like we can negotiate and trade back and forth. But I feel like we ought to be able to ask questions and get answers to the questions. Were you ever presented with a ready-to-sign copy of a PPA prior to the pricing change? No.
And so you never refused to sign an agreement before the pricing changed?
No.
I just have a couple more questions in conclusion, and then we'll let the other parties ask you whatever they have. For the benefit of the commission, will you summarize your testimony today and also describe the relief that you would like to see be granted?
Well, I don't know if the delays by the power company were intentional or not. I have no way of knowing that, but they certainly weren't our fault. And, we were promised the old rates. We did everything we could to lock in on those, and I just feel like we deserve them, or we wouldn't be here today.
And what would you like the commission to do? I assume you would like the commission to grant the old rates and then allow the payments under this current interim PPA to be trued up. Is that?
That's true.
I have no further questions for you, Mr. Castor. Thank you.
Yep.
Ms. Hogle, any cross? Absolutely. Mr. Jetter?
Good morning. I do have just a few brief questions for you.
Sure.
And they relate to the insurance. I don't believe that on the record before the commission there's any indication of the, what I'm trying to find out is what's the value difference between the premium for the policy under what I suppose was under the old contract or what you were requesting from Rocky Mountain Power, and the increase in the amount of the coverage. Do you know that?
I think the for a single project, a $5 million umbrella is in the neighborhood of $8,000 per year. For a $3 million, it's probably closer to $5,000 or $6,000 per year.
Okay.
I mean, it's not huge, but it adds up, and it is quite a bit of money for a small project.
Okay. That's the only question I had for you this morning. Thank you.
Okay.
The office has no questions, thank you.
All right, Mr. Castor, I have just a few questions. First of all, I was a little confused about your position at the company. Are you an employee or a principal or an independent consultant?
I work for Thayn Hydro,
Okay.
and I'm also a co-owner on the project.
And I'll pose this more to your counsel and the other parties' counsels respectively. There were emails attached to multiple of the briefs that were submitted to the commission. Mr. Castor, you were party on most of those emails. I think there were one or two that might have been company internal emails. To the extent any party wants to admit the emails that Mr. Castor participated into evidence, I think Mr. Castor is best situated to authenticate those and testify to their veracity. And so I would just put that question to first your counsel and anyone else who would like to ask Mr. Castor about those emails.
Yeah, I think that would be proper, and I suppose it's also proper to have Mr. Castor testify as to the accuracy of the facts contained in the various pleadings. You know, to the extent they are factual, they are based primarily on his knowledge.
It's pretty much all true as far as I can remember. There's been quite a few briefs.
So, Mr. Long, do you want to actually take Mr. Castor through any exhibits that were attached to the briefing, or do you want him to make a statement that he's reviewed all? I mean, how do you want to proceed?
I don't think it's necessary to go through them one by one. I guess, Mr. Castor, to the best of your knowledge, are the factual statements contained in the pleadings filed by Thayn Hydro true and accurate?
Yes.
And are the emails attached to the various pleadings filed by both Thayn Hydro and the other parties, are those emails that were sent and true to the best of your knowledge?
All of the emails that I was a party to are actual emails, if that's what you mean.
Is that sufficient, Mr. Hearing Officer?
Yes, thank you. Anyone else want to add anything on that subject before we continue?
Mr. Hearing Officer, I just have a question. Would it be then appropriate to, at this time, move for the admission of all of the pleadings that contain, all of the pleadings, period, as evidence into the record?
Well, all the pleadings are certainly in the record, but they take different form, and I can't recall the form of each one off the top of my head. For example, I know Mr. Long was the author of the documents that Thayn Hydro filed. So any representations made in those are the representations, for example, of Thayn Hydro's counsel. So I don't think it would be appropriate to admit those representations as evidence. They're certainly in the record, and as are all the parties' filings. But to the extent you want the commission to consider factual evidence in this docket, I think it would be appropriate that any exhibits are attested to or identified that you'd like the commission to consider.
Certainly, Your Honor. The company moves then for the admission of its pleadings in addition to any accompanying exhibits that are attached thereto as evidence into the record, including its application.
Let me finish with Mr. Castor, and then we will revisit this before we proceed. Mr. Castor, were you aware that Rocky Mountain Power had sought to make changes to the Schedule 37 pricing in May 2014? There was a docket, it was docket number 14-035-04. The commission ultimately denied some of the changes the company wanted to make, and the company and the Division of Public Utilities appealed the commission's decision, and it was actually on appeal as late as December 2015. I just wondered if you had any awareness of those proceedings.
No, I haven't really paid attention to the various schedules.
Thank you. Mr. Castor, and I apologize if I didn't catch this the first time, if you spoke to it. I heard you speak to the materiality or lack thereof in your view of the insurance requirements, or at least the fact that Rocky Mountain Power's unwillingness to lower the insurance requirement would not have prevented Thayn from entering the contract. My understanding is there was also some discussion and negotiation about default provisions. Can you speak to those negotiations and whether the outcome of them may have precluded Thayn Hydro from proceeding and entering a final contract?
No, there were no provisions that would have prevented us from signing the contract.
Thank you. And this might be a question better directed or as well directed to the Division of Public Utilities, but my understanding is that Thayn did at one point file an informal complaint with the division. I don't know if that complaint was abandoned in light of Rocky Mountain Power's filing of an application in this docket, but can you give me an understanding as to what transpired with respect to that informal complaint?
Yes, we did file an informal complaint, and then it kind of got taken over by this mutual application, I believe.
Okay, that's all I have. Thank you, Mr. Castor.
Thank you.
I have just a couple of redirect questions, if I may. Mr. Castor, you mentioned that the $5 million umbrella policy requirement that was new in this PPA would cost Thayn Hydro about $8,000 a year.
That's correct.
Do you know off the top of your head about how much power Thayn Hydro sells to Rocky Mountain Power every year? You know, a dollar value that you receive from Rocky Mountain Power?
Well, it depends on the rate for that particular year. I think with the existing rates, we're probably looking at, I don't know, give or take 100,000 per year.
So currently the amount of power you're selling to Rocky Mountain Power is in the six digits.
Yes, I would say so.
And just one final question to reinforce your points. At any point in this process, did you expect to not sign a renewal PPA?
No.
I have no further questions. Thank you.
Mr. Castor, I have one
Okay.
follow-up, which is actually off point, but I neglected to ask it to you the first time, and I apologize for that. I'll give your counsel an opportunity to follow up if he desires to. But you made some statements essentially suggesting that there are no other takers for the power that Thayn Hydro generates. Can you elaborate on that a little bit?
You know, the few times I've looked into wheeling power years ago, it was very cost prohibitive. A lot of utilities, if they want to buy power, they want to buy it in huge blocks of power that we're not capable of delivering.
And did you explore that option at all during the negotiation process for this renewal?
Not really.
Anything else?
No questions. Thank you.
Thank you. You're excused, Mr. Castor.
Thank you.
So we'll return.
Hearing officer?
Yes.
I don't know if this will be useful at all, but I do have some copies of some emails that could be more formally introduced if you think that would be necessary or helpful.
Was it your intention to do so during your presentation of evidence?
No, these are all Mr. Castor's emails. I just had them.
You know, I think probably the best solution will be for us to have all the parties present their evidence. We'll have a short recess. I'll look over my notes, and maybe you all can discuss amongst yourselves, perhaps stipulating to the admission of certain emails. Does that sound agreeable? Mr. Long?
Yes, that would be fine.
Ms. Ogle?
Well, I suppose I'm not, first of all, is it okay if we go
Are you concerned about confidential information being disclosed?
But I just want to discuss the process as it comes up. And I don't know if that comes up later. I'm concerned about his use of the stipulated, stipulated to the emails, given that, the company used certain emails in its agreement, and to the extent that Mr. Castor has already indicated to hit the rest of the emails they're accurate, I'm not sure what was stipulated in the agreement, and I'm not sure whether you want to discuss it on the or off the record.
Well, no, that's why I thought the parties might do so off the record while I was out of the room. My recollection was that there may have been an email or two that were internal to the company to which Mr. Castor wasn't a party. I don't know that Mr. Clements was a party to all of those emails. I don't know if there would be any objection to their admission. The commission's not formally bound by the rules of hearsay, but I thought I'd allow you all an opportunity to talk about it off the record. So may we proceed? Mr. Jetter?
Thank you. The division would like to call and have sworn in Mr. Charles Peterson.
Mr. Peterson, do you swear to tell the truth?
Yes.
Morning, Mr. Peterson. Would you please state your name and occupation for the record?
Charles E. Peterson. I'm a utility technical consultant with the Division of Public Utilities.
Thank you. And in the course of your employment with the Utah Division of Public Utilities, did you have the opportunity to review the application filed by Rocky Mountain Power in this docket?
Yes.
And did you create and cause to be filed with the commission an action request response dated March 2nd, 2016?
Yes.
Are there any edits or corrections you'd like to make to that?
Yes, one small one. On page 2, the paragraph before the section that's headed discussion, I referred to the date in which comments were due as March 10th, 2016. That was actually the date for reply comments. The correct date should have been March 3, 2016.
Thank you. And we discussed briefly entering some various evidence into the record, but my specific question for you is, as you look through the page 2 and 3 of that division memo, there are a number of bullet-pointed facts, which are generally dates of and occurrences of events. You don't have personal knowledge of those, do you?
No, I relied on documentation provided either by, I think mostly by PacifiCorp.
Okay. And that was largely from the same emails we've discussed earlier about entering those into the record?
Yes.
Okay.
I also, as a correction, I believe there are also some copies of telephone records that would seem to indicate apparently or confirm certain dates of phone conversations, but we also had that kind of information available to us.
Thank you. And you had that information available, just so it's clear for the record that that was available and provided by the parties through data requests?
Yes.
Correct. Okay. Would you like to give just a brief summary of?
Are we going to ask for the admission of a memo or not?
I was intending to wait, and I
Okay.
think we were going to do kind of a bulk
Okay.
admission.
That's fine. Answer to your question about a brief statement, yes, I have a very brief statement because the division believes that its position is well set forth in the division's memo of March 2nd, 2016, as well as in the brief of its counsel dated May 6, 2016. Briefly, Based upon the specific facts of this case, the division supports granting the earlier Schedule 37 pricing that was in effect in July 2015. And also the division does not at this point object to a 20-year term for the contract between PacifiCorp or the proposed contract between PacifiCorp and Thayn Hydro. And that concludes my comments.
Thank you. I have no further questions from Mr. Peterson. He's available for cross-examination.
Ms. Hogle? Mr. Long?
No cross.
Mr. Moore?
No cross.
Thank you. I don't have anything for you, Mr. Peterson.
Okay, thank you.
Mr. Moore?
The office calls Bella Vasta.
Mr. Vastag, do you swear to tell the truth?
Yes.
Thank you.
Mr. Vasquez, could you please state and spell your full name?
My name is Bela Vastag. That's B-E-L-A. Last name V-A-S-T-A-G.
What is your occupation?
I am a utility analyst, and I work for the Utah Office of Consumer Services.
During your course of employment at the office, did you have the opportunity to review the application in this case?
Yes.
Have you reviewed the docket in this case?
Excuse me?
Have you reviewed the entire docket in this case?
Yes.
On March, did you participate in the preparation of the March 3rd, 2016 comments from the Office of Consumer Services?
Yes, I did.
Do you have any changes you would like to make to those to that?
I have no changes.
Would you adopt these comments as your testimony?
Yes.
Deviate slightly from the divisions. We would like to introduce those comments into evidence at this point.
Any objection? They're admitted.
Have you made a brief statement? Have you prepared a brief statement summarizing the position of the office at this time?
Yes, very brief.
Could you please read it into the record?
Absent a decision by the Commission that a legally enforceable obligation, or LEO, exists such that Thayn Hydro is entitled to outdated prices and terms, the Office of Consumer Services' position in this proceeding remains the same as presented in our comments dated March 3rd, 2016, that the terms of Schedule 37 should be followed and that the price and terms used in QF PPAs under Schedule 37 should be those in effect at the time the PPA contract is executed. Should the Commission decide that a LEO was formed with Thayn Hydro at some point in time, the Office requests that the Commission consider in its decision the argument in the Office's response legal brief dated May 6th, 2016. The Office does not believe it is necessary for the Commission to make a broad determination of when a LEO exists in this proceeding. The Office, however, suggests that the Commission open a new proceeding to consider such broader issues as well to update the language in the Schedule 37 tariff as appropriate. That concludes my statement.
Mr. Vasek is now available for cross-examination.
Ms. Hogle? Mr. Long?
No cross.
Mr. Jetter?
No cross. Thank you.
Mr. Is it Vastag or Vastog? I want to make sure I enunciate it correctly.
I say Vastag.
Vostok, thank you. Mr. Vostok, in the statement you just gave, you stated the office requested the Commission consider in its decision the argument, the office's response legal brief in its decision the argument, pardon me, the office requested the commission consider in its decision the argument in the office's response legal brief dated May 6, 2016. Sorry, I butchered that. And this question might be better directed to your counsel, but is there a particular portion of the brief or particular argument in the brief that you're referring to, or just the entirety of the contents of that document?
The entirety of the contents of the document, it was written to give a background and then to answer a specific question.
Okay. Thank you. Well, if there's nothing else from the parties at this time, then we will recess briefly. To be clear, what I'm suggesting the parties do is perhaps discuss whether they can stipulate to the admission of any emails that were attached to any briefing in this case that have not already been introduced. I think that it would be the most expedient way to handle the issue to simply allow you to discuss it amongst yourselves off the record. So I'll give you a few minutes to do that, and we will reconvene in perhaps 10 minutes. Back on the record. Did the parties have an opportunity to discuss the admission of emails attached to legal briefs and other filings in this case?
Yes, Your Honor.
And was a stipulation reached?
Yes, and the company moves on behalf of all of the parties in this case for the admission of all of the emails that were attached to all of the pleadings that were filed in this case, in addition to the admission of all of the comments that are not pleadings, including the application, the original application, and everything that has been filed formally with this commission as evidence in the record in this case.
I assume from Ms. Hogel's having articulated that as a joint motion, there is no objection.
No objection.
Okay. Thank you, they're admitted. And I appreciate that stipulation. For the party's benefit, I'm not attempting to make this process more laborious than it needs to be. I just simply want to make sure we have a clean record in the event there were an appeal. So thank you.
And Your Honor, I apologize. We also conferred and would like maybe the opportunity to make a short closing statement, or at least allow parties to make a short closing statement if that's what they want.
Of course, that'd be fine. We will begin with you.
Okay, thank you. Under Utah law, avoided cost pricing for Schedule 37 is based on the currently effective Schedule 37 rates. The Public Service Commission must follow that law unless it is shown by substantial evidence that Thayn Hydro is legally obligated to deliver power to PacifiCorp. Rocky Mountain Power's position is that Thayn Hydro has not supported its claim by substantial evidence. Having said that, this commission has vast discretion to make a finding in this case based on the unique and extenuating circumstances present that will result in just and reasonable results and that are in the public interest. Thank you.
Thank you, Ms. Hogel. Anything from you, Mr. Long?
Yes, I'll also make a very brief closing statement. Thayn Hydro unconditionally committed to sell its output to Rocky Mountain Power prior to the order on September 18th, 2015, modifying the Schedule 37 pricing. As such, if the Commission desires to address the legally enforceable obligation issue, it is clear that Thayn Hydro and Rocky Mountain Power did establish a legally enforceable obligation to sell and buy power, respectively, prior to the pricing change. Thayn Hydro further asserts that the Commission can reach this conclusion without setting any Utah-specific precedent. The Commission can reach this conclusion based solely on existing FERC precedent. That said, Thayn Hydro believes that the Commission has the power, under its extremely broad authority over public utilities granted by statute, to resolve this issue without addressing the legally enforceable obligation question. The Commission has the ability to determine that the Thayn Hydro PPA should include the old Schedule 37 pricing based on extenuating circumstances. Thayn Hydro asks that the Commission recognize that fairness requires that the PPA include the old Schedule 37 rates.
Thank you, Mr. Long. And this question is directed to both Ms. Hogel and Mr. Long to the extent they're inclined to answer it. But the extenuating circumstances argument that both of your clients are asserting, is that based solely on the language in Schedule 38, or are you looking to Title 54 or other legal sources in support of that argument?
I suppose I can go first.
Okay.
I believe that it's both. You do look to Schedule 38, and the reason why is, as Mr. Clemens indicated, there are no set procedures in Schedule 37. One, and second, there are many cases in which the Commission, or it is clear that the Commission has vast discretion in its authority to regulate public utilities to reach results that are just and reasonable and in the public interest, in addition to, in specifically statute, the utility code in Section 54. Thank you.
Thank you.
Thayn Hydro likewise believes the commission has extremely broad authority over public utilities granted to it by statute. Thayn Hydro believes that the commission has that power to fix things that have not happened as they should without reliance on Schedule 38 or any other Rocky Mountain power tariff. If the commission has the ability to simply make the world as it should have been, and that is all that Thayn Hydro is asking the commission to recognize that the situation should have worked out differently because of circumstances, really, a perfect storm of circumstances. We ended up here, and really we shouldn't have.
Thank you, Mr. Long. Mr. Jetter?
Thank you, Your Honor. In just a brief closing statement, I'd like to put on the record now that from the division's point of view, this is a unique circumstance that rarely occurs, where you have particularly a Schedule 37 negotiation that spans the time frame of two different pricings. The division opposed the old 37 pricing when it was put into effect. We appealed the commission's final order in that docket. But we're here today in support of providing that pricing because we believe it was the pricing in effect at the time that Thayn Hydro sought a renewal. And in particular in 37, I think the idea is to satisfy PURPA's regulation, which specifically I'm looking at 18 CFR 292.304 subpart C, which is the standard rate for purchases. And it's a standard rate for purchases for small qualifying facilities. And the reason that those exist is because in those small contracts, the transaction cost of a substantial long negotiation with individualized project pricing may be such a high transaction cost that it would thwart the sale of energy from small power production facilities that are under 3 megawatts in our case. And I think that really is the reason that Schedule 37 does not include a more full guideline for walking through the entire negotiation process like Schedule 38 does. And the fact that it doesn't include that kind of leaves us in a bit of limbo because we don't have a specific timeline for moving through a 37 project. And for that reason, I think it is reasonable to look to 38 as, it's certainly not binding. 38 is clear that it doesn't apply to a project under 3 megawatts. However, I think that the principles involved in negotiating some of the non-pricing elements are similar, and to that extent, it might be persuasive, if not binding, to look to Schedule 38 for the idea of potentially an extenuating circumstance decision in this docket. With respect to whether a legally enforceable obligation occurred in this case, FERC and the federal laws provide states fairly broad authority in determining when that is, and something that might be a legally enforceable obligation in one state may not be in another. And in Utah, we haven't thoroughly sorted that out. I think we generally are in agreement with some of the other parties that defining the boundaries of that for Utah might be more appropriate to do with more parties involved. And for that reason, in the instance or in the outcome, if it were the outcome that the commission found a legally enforceable obligation to be in existence in this case, granting the prior pricing from the earlier Schedule 37, the division would simply request that an order, if it is in that nature, be very narrowly construed to the facts of this case and leave a determination of sort of the bounds of what a legally enforceable obligation might be. Leave those a little more open to potentially a future rulemaking or something along those lines. And so that would be our suggestion as far as if the commission determines that that is the case, to have a narrow ruling. And to reiterate, the division is not opposed to the idea of a extenuating circumstance in this case, because we do believe that the prior 37 pricing based on the facts that happened would be a just and reasonable outcome in this specific instance with these specific facts. So that's my closing statement.
And as I posed to Ms. Hogle and Mr. Long, would under this theory of an extenuating circumstance justifying granting Thayn Hydro the otherwise outdated price, is it the the division's position that the commission's authority to grant that stems from its broad powers under Title 54?
Yes, I would say it's from the broad powers under 54. I don't think that there's a plain reading of Schedule 38 as it currently exists that would support a direct application of 38. I think it would merely be a situation where we don't have a specific tariff or rule that covers this type of negotiation. Schedule 37 does have some language in it that's somewhat limiting on signing a contract, a PPA, with pricing that's not in effect at that time. But I think it's possible for the commission has authority to find a special circumstance where that pricing would be appropriate with that language, because in my opinion, that language is really a limitation on Rocky Mountain Power's ability to sign the contract, not necessarily the commission's authority to approve that pricing and potentially I suppose a reviewed exception to that.
Thank you. And on the Leo issue, would I be correct in summarizing that the division's position is that it's ambiguous or perhaps undecided as to whether a Leo can be shown or has been shown to exist in this particular circumstance, but in the event the commission were to find that one did, any order should be narrowly drawn and construed to apply to the circumstances at issue in this case?
Yes, that's exactly accurate, I think. And as just to add a little bit to that, as I've looked through some other states that do have more concrete rules, whether they're from just precedent of commission's orders, the facts in this case could be a Leo in one state and not in another. So it's really a borderline case, in my opinion, which is probably why we're here. And by that I mean it's a borderline on it might be at the edge on some cases and might not be a Leo in others. It's not on the other border where it almost certainly is, for example. I think it's a maybe.
But the division has not elected to advocate for any particular standard in this docket.
No, I think we'd like to have some more parties involved if we were setting a complete standard in something like an administrative rule.
Thank you. Mr. Moore.
The office will rest on its pleadings on the issue of what constitutes a Leo and whether Leo is in this case. We briefed it kind of extensively, and I don't know that I disagree with or have any comments on the other parties' explanation of their positions. I do want to make two brief comments on an issue where we're a little bit contrary to the other parties in this docket. First one is the exceptional circumstances. We, in our briefing, argued that they should not apply primarily because the term exceptional, in the Three Peaks case, the term exceptional circumstances is in existence in Schedule 38. And we are uneasy with the notion that a term such as broad as exceptional circumstances should be read into the entire utilities code. For that reason, we don't believe that issue should be decided on the exceptional circumstances approach. Also, we believe that that's contrary to the March 16, 216 provisional conclusions of law, where the commission said that absence of showing of the Leo existed, the commission will not order RPM to enter a PPA using price terms contrary to the applicable tariff. That appears to be the law in this case, but since it was interim order, certainly the commission can change their minds on that point, and the parties can urge positions to change their minds. We would just state that given the fact that it is the law of the case at this point, the commission does not need to address it. It can rely on the fact that they have addressed that issue in their March 16, 2016 provisional conclusions of the law. We also state that we feel that the Schedule 38 language as it now stands is inconsistent with FERC precedents rather clearly in the Idaho cases which we cited, and I believe the division cited, and I believe Thayn cited. They were very clear that a bright line test of signing a contract is insufficient to comply with the legal concept. Because of that, we agree with the division that we should probably have future proceedings to amend Tariff 37 and to address the Leo doctrine on a broader scale than just to focus the facts in this case, which are unique. Thank you.
Thank you, Mr. Moore. And I don't mean to put you on the spot, but if, to the extent the commission were to agree with the other parties in this case who have suggested that Title 54 would empower does empower the commission to grant the otherwise outdated pricing to Thayn Hydro based on its discretion. We can use the term extenuating circumstances, but it's really, I think the argument is it's a matter of the commission's discretion, or within the commission's discretion. Does the office have any comment, or does it agree?
We are, certainly the commission can exercise its discretion, however it wants within the statutory framework. We're a little concerned that that's too broad a brush to paint the entire utility code with. We think that a better approach would be to amend Schedule 37, and if we need a exceptional circumstances language, to include it in the tariff.
Does anyone have anything else before we adjourn?
Mr. Hearing Officer, I have one point that Mr. Castor addressed that may have not been stated explicitly. So the current situation with Thayn Hydro is that the project is generating power and is being sold to Rocky Mountain Power under an interim power purchase agreement with the current Schedule 37 rates. In the event that the commission orders the PPA the PPA that's the subject of this application to use the old Schedule 37 rates, Thayn Hydro asks that order also include a true-up of payments made under the interim PPA. So in other words, from Thayn Hydro's perspective, to make those old prices effective from the date of the interim PPA, which was at this point several months ago.
Thank you, Mr. Long. Does anyone have anything to add? Thank you. We're adjourned.